The Sarasota County Bar Association is a proud partner in bringing you law in Sarasota. With voluntary membership of over 1,000 lawyers and judges, the Sarasota County Bar Association serves its members and your community by advancing legal professionalism, promoting practice development, and fostering fellowship. Visit www.sarasotabar.com for more information and to use the online directory to find an attorney.
This program is brought to you by a grant from the Community Foundation of Sarasota County and the Sarasota County Bar Association. The Education Channel produces the program and broadcasts from its state-of-the-art campus on Beneva Road. They make this program possible.
Hello, and welcome to another episode of Law in Sarasota, a program of the Sarasota Bar Association made possible by the Community Foundation of Sarasota. I'm Erica Quartermain, a county judge in Sarasota. Thank you for joining us in our continued effort to provide topical legal material to the folks in our community and capture the legal history of this great place. Property insurance. It's a topic that has received a great deal of attention lately. Some refer to the state of property insurance in this state as a crisis. In the last week, we have seen headlines in the news that policyholders have filed the highest number of complaints with the state against their insurance carriers, that insurers are leaving the state of Florida, that people are being forced to move out of Florida because of skyrocketing premiums, and more people are going to the insurer of last resort, Citizens. Over the last 2 years, a number of bills have been passed that significantly changed Florida's property insurance statutes. These changes include the removal of one-way attorney's fees provisions in favor of policyholders, abolishing assignments of benefits under property insurance claims, heightening communication requirements for insurers, creating shorter claim reporting deadlines, allowing for mandatory arbitration, creating additional conditions precedent in bad faith claims and a policyholder's use of a public adjuster, among other significant changes. Here to discuss this today are two attorneys practicing in this field, one on the side of the policyholders and one on the side of the insurer. On the side of the policyholder, I am pleased to introduce Vanessa Ross. She's the principal of Ross Legal Group, which assists homeowners and businesses in recovering insurance proceeds and from their property and casualty insurance providers. She has a bachelor's degree in business administration from the University of Florida and her law degree from Florida State. In her career, she represented insurance companies for 10 years prior to switching sides. She has litigated hundreds of lawsuits relating to property damages in homes, business, large commercial buildings, and condominiums. She has handled trial-level cases and appellate-level cases. Welcome, Vanessa.
Thank you.
On the side of the insurance company, we have Kenneth Hall. Mr. Hall graduated with his bachelor's from the University of Virginia, and he went to the Florida State University for Law School as well. For 12 years now, he has worked on the insurer side in various capacities. He is currently in-house counsel for Universal North America Insurance Company, which is headquartered right here in Sarasota. So welcome to you both. Let's start this conversation with some basics, and I'm going to start with Ken. If a property owner wants to go buy insurance, tell us who is involved in that and what is involved in that.
Sure, Judge. So there are a number of ways that property owners can get homeowners insurance. There are several online resources for citizens to research rates and companies that they may want to get a policy with. There's also agents. I think that's probably the most common and widely understood way that citizens can get insurance. And oftentimes through a home purchase process, a real estate agent will be connected with an insurance agent and will present some options for a policy for a new house or for a house that someone's buying. The agents are agents of the insurance companies, and so they are authorized to sell insurance policies for the companies that they work for. And agents will work with the homeowners to understand their coverage needs and to hopefully explain the product that they're purchasing whether there are any exclusions or unique terms and conditions to the policy, and the agents will help place coverage there. On the citizen side, they can work with brokers. Brokers are a bit more independent of actors. They're not bound to work for any particular insurance company, and they are really more aligned with the interests of the homeowner. From the insurance company's side, the next step in the process is something called underwriting. And with underwriting, it's basically where the risk of insuring your house is assessed and analyzed, and a rate is made that is that coincides with that risk assessment. So if it's a particularly risky property, say if it's on the coast, if it's by a body of water, an underwriter may assess that at a higher rate, and that would in turn lead to increased premiums. That's basically the process and some of the players that are involved in procuring an insurance policy.
Okay, and who are the reinsurers?
So the reinsurers are kind of a level above what maybe a common man, a common person might understand in terms of players in the insurance industry, but reinsurers are basically insurance for insurance companies. So insurance companies themselves will go out into a global market and purchase policies that protect the company itself. And those policies are extremely important in years where there are unprecedented catastrophes, hurricanes here in Florida. So with Irma back in 2017, with Ian this past year in 2022, that's when these reinsurance contracts get tapped, because the insurers simply can't carry enough capital to adequately insure against the risk of those extreme, rare, very damaging catastrophes. And so that's when they go to the reinsurance companies to basically act as an insurer for the company.
Okay. So I'm going to turn to Vanessa, and I mentioned what some people are describing as a crisis. So are we in a property insurance crisis?
Yes, I would say that's fair to say. The companies in Florida have really been challenged. They've been the reasons for that are multifold, and so there's been a lot of debate over why we're in this position. But some of the big reasons are that, well, it stems back from 2004, really, is when Hurricane Charlie, we got 4 major storms in the course of 1 year, and then Hurricane Wilma in 2005. After that, storm after storm after storm, a lot of the major carriers from the nationwide type insurance companies left Florida. At that time, there was a lot of discussion in the political arena to force the Allstates, the Nationwides, the State Farms, Farmers, all those commercials that you see on TV for insurance. None of those big guys write property coverage in Florida. They refuse. Or if they do, they write it under a small little company that if it has to go under, they can let that go and keep Allstate together. So back then, there was a lot of political push to say, let's force State Farm if they want to write auto coverage in Florida, which is very lucrative for them because we have a lot of people here, we should force them to write property. Well, that was not done back then. They decided, no, we're not going to force them to do that. So what that led the market in Florida to have to do is bring in and encourage small companies to start writing policies. They were called takeout carriers. And these takeout carriers, all you really needed was a small amount of capital, a couple $1 million, and citizens would give you policies. So a lot of the companies here in Florida today are takeout carriers. They're small. They haven't been around for 100 years like the Hartford. They're not well capitalized. And it only takes a couple things to make them go out of business. And that we've seen that happen time and time again with these smaller companies. Definitely up for debate why that happens. Some of it is because of hurricanes. Some of it is because of a lot of lawsuits that have gone crazy. But a lot of it has to do with just management, their book of business, and their reinsurance capabilities. So I think that's why we've ended up in this scenario, because the bigger insurance companies were not forced to keep writing in Florida. So now we're ending up with either the insurer of last resort, which is Citizens, that is state funded, or a lot of very small companies that are struggling, I think, right now.
Well, Ken, what do you think? Are we in a crisis?
So I think It's an interesting question, and I appreciate Vanessa's perspective on it. I think that you can define a crisis from different perspectives. So, from a homeowner's perspective, I think that you look to the paper and the news stories, and every other day it seems that there's an article about increasing rates, about folks that are forced to leave the state because they just simply can't afford to live here anymore. So I think for them it's certainly a crisis. For the companies that have gone under in recent years, there's been a handful of insurers, and some of the bigger ones too have chosen to pull back from Florida. So it's not necessarily everyone just going out of business, but making business decisions to not insure in Florida because of the cost. And so for them and for the companies that have gone under and for their employees, I certainly think it's a crisis there. And I agree that it's multifaceted, and there's a number of reasons that can be pointed to. We do live in Florida. We have our fair share of bad weather, hurricanes, as I've mentioned, but other states have hurricanes too. All of the Gulf states have hurricanes. So Texas has hurricanes, Louisiana has hurricanes. But Florida seems unique, and what I would point to in terms of what makes up that uniqueness is our capacity and appetite for litigation. And so that's something that I would point to that's been maybe underappreciated, maybe underreported on, is the volume of resources that insurance companies have to expend on litigation. So not just paying its own lawyers and defending the lawsuits, but until the recent reform in terms of the one-way attorney fee statute being repealed, paying a significant sum of money to plaintiff lawyers as well. And there's a statistic that's often quoted, and I won't get it exactly right, but it's something about how Florida has 8% of homeowners claims nationwide. So among the country, we're responsible for 8% of it. But when you look at the percentage of litigation that we're responsible for, it's 80%. And so something was out of whack there in terms of incentives and drivers and where the money was going. And so that has changed though with the recent reform. But that's what I would point to as one of the biggest drivers of what I would call a crisis.
Okay. So the insurance companies that go belly up, what happens to their policyholders?
Well, I'm not an expert on what happens to those policies, but I know that there's an organization called the Florida Insurance Guarantee Association, or FIGA, and I know that it's FIGA's task and what they're charged with is paying and closing valid claims that are still open if an insurer goes out of business. Vanessa might know a little bit more about
I
that.
deal with FIGA on a daily basis because a lot of the carriers have gone under, and especially UPC, United Property and Casualty, was a major insurance company in Florida that went out of business after Hurricane Ian. So I represent a lot of hurricane victims who have no insurance company. And the sad part about that is FIGA, they do what they can, but they are in no means an insurance carrier. They are not there to reassess your claim. They are not there to try to negotiate with you. They're there to take what the carrier did before they went out of business, and sometimes that carrier mismanaged the claim, didn't adequately analyze it at all, and because of that, my clients are handcuffed into that decision. And they pay really pennies on the dollar. And it's a hard fact to face, that you paid insurance, you had a policy, you had a major storm, major loss, and this carrier is gone. And the state is trying to help you, but there's such a delay as well. The FIGA statutes say that FIGA has a 6-month stay. So UPC went out of business in February. We are just now being able to negotiate claims. We're starting at day one right now. And it's almost been a year since Ian. So when government officials say, don't worry, there's FIGA, it's not the same. And it's frustrating to see a company like UPC that is a nationwide company. It's operating in multiple different states. They're still operating. They still have money, but we're left holding the bag.
And that's one of those smaller companies in and of themselves in Florida? that they've used as a separate company. Is that what you're saying? And that's what allows them to still operate other places?
So technically, and I'm not a corporate lawyer, but like, for example, Allstate has Castle Key that operates in Florida, so that Castle Key is its own entity. UPC was not structured that way, but the state of Florida gave them permission to stave off their Florida and keep their other business afloat. So they allowed them to leave the state, which I disagree with that decision.
Who's involved in that decision, do you know?
The governor.
Okay, all right. And I suppose it's a good thing
I'm sorry, the Office of Insurance Regulation really is but the governor had a lot to do with it.
Okay. And obviously, the company you work for is solvent because you are working there, and they are here in Sarasota. That's an attribute to have a company that size here in Sarasota. So it's probably a good thing that you haven't had to deal with being insolvent. So that's a good thing.
Absolutely, yeah. Universal is not just a Florida company. We write policies in 16 or 17 different states. So it's a matter of not having all your eggs in one basket, I think. Okay,
got it. So we've touched a little bit about how the new laws are going to affect things and the situation that has unfolded over a number of years. So I'm gonna start with Vanessa, and I'm going to ask you to tell us what you think are the most significant laws that have changed or been created and how they affect policyholders.
Yes. Well, let me start with a brief history. 1893 in Florida was the first attorney fee statute for insurance, again, when a homeowner is suing their insurance carrier. So for over 100 years, 130 years, we've had this right. And the whole basis of it was that, and there's been many constitutional challenges over the years. 1956, I think, was when this statute that we currently had was put into effect as it stands right now, 627428. And that statute provides that if a policyholder has to sue their insurance company, they're entitled to one-way attorney fees. And that was meant to even the playing field because homeowners are small homeowners, they may have a $10,000 claim, and they're going against a major corporate entity. Also, the policies of insurance are called adhesion policies, which most attorneys know what that means, but it's basically a non-bargain for policy. And anyone who's an insurance agent will tell you the homeowner has no bargaining power. They can't change the policy. They're basically handed a policy and the terms in which you just have to agree with. Most homeowners don't even know what the terms are when they pay their premiums. So that's why it also gives that shifting. And anyone who's glanced at an insurance policy knows that on first reading, you're wondering, what does this even cover? Because half of it is exclusions. So in order to prevent insurance companies from applying exclusions willy-nilly, not paying claims appropriately, this one-way fee shifting statute was given to us. This was just taken away completely in 2022. Thankfully, for the hurricane victims of Ian, it happened 2 months after the storm. So that means that their policies are still provided with this protection. Going forward, it won't be that way. This storm, it will not be that way. If one comes. The frustrating part is that there was a change in early 2022, which gave us this notice of, we would have to provide a notice before we file a lawsuit. And I think that was a good change. It was 2021, I believe. And the notice of intent statute makes it to where we have to give notice before just filing a lawsuit. And this puts the carrier on notice that there's a dispute. Estimates have to be provided, a disputed amount has to be provided, and if the carrier doesn't pay it and forces the insured into a long litigation process, then a portion of the fees may be collected. I think that was a very beneficial change that happened, but unfortunately, the governor, in combination with a supermajority of Republicans in our legislature, wouldn't let that play out, and within a year, completely stripped away the right of attorney's fees at all. So right now, we're in a complex situation where we've got claims that are from 2020 that have one version of the law that applies to them, claims from 2021 to 2022 that has this notice of intent and quasi-fee shifting and sort of a middle ground that I believe we should have stuck with. And then now future claims going forward will have no attorney fee right at all, unless there's some allegation of frivolousness or a proposal for settlement, which is still available. So it's complex. And there's also been reductions in the ability to sue for bad faith. So if there's any bad faith claims handling, the insurance company has a lot of avenues to escape liability on that as well.
Can you elaborate on what bad faith would be?
Sure. So in Florida, we have a separate cause of action for bad faith. That's a separate tort cause of action. And in Florida, the way it has operated up until now has been if one files a lawsuit, wins, and the insured had filed a civil remedy notice, so you put the carrier on notice of either claim delay, claim denial, unsatisfactory settlement offer, unfair trade practice, unfair business practice, then, and they don't cure those defects within 60 days, then that leaves them exposed to a potential second lawsuit. So you have to win one lawsuit first. If you win, you can sue them again. And that was beneficial because I think it kept carriers in line. They were rightly so worried about such a lawsuit because that lawsuit came with punitive damages, which really gets the carrier's attention. What this new statute has done, this framework has made it to where those claims are almost impossible without going through a full 3-year litigated case and full trial and appeal, and then maybe you can get to your bad faith claims. So when you have clients come to you saying things like, I'm living in a trailer, I have 4 children, I have 2 dogs, the trailer's air conditioning keeps turning off, the carrier's not responding to me, what do I do? This is bad faith, my life is ruined because I can't fix my house. I have to tell them, you have a 3-year road ahead of you before you can even make those allegations. So that's frustrating, for sure.
All right. So, and I know there are a lot of changes. I tried to read them all, and it's a lot. So, Ken, tell us from the insurer side what the biggest changes are in your opinion, and the practical effect for insurance companies.
Yeah, sure. So, I would echo Vanessa in mentioning the fee statute. I think it's important to her and her side and to the insureds, and it's also important to the insurance company. It was certainly the most controversial and heavily debated change I think that came about in this last session. But the problem that arose from the one-way fee statute, there's a couple things to note about it. First, it's not that you as an insured just win your lawsuit, meaning you get everything you ask for. The way that the one-way fee statute operated was that if a jury found that the insurance company had underpaid by just $1, they didn't get it exactly right to the penny, then not only does the insurance company have to pay that difference to the insured, but also pay for the attorney to get that result. And so there's a bit of an imbalance and an inequity in terms of punishing the insurance company, which it's really a punishment to pay the fees of the attorney that this person had to hire if the result is not so, tied to that. It's not so egregious. What this practically did was kind of you have a policyholder and you have their attorney, and they can have divergent interests. So, and I'm not trying to paint Vanessa with this broad brush, but there are some bad actors in the state who weaponized litigation to collect as much of a fee as possible. And so in those circumstances, the attorney's interest in being difficult in the litigation, being acrimonious, having to come to you in a hearing for motions to compel or trying to get dates for stuff, or just people not cooperating and playing nice, all that friction actually inures to the benefit of the attorney because he gets to bill for all of that. So they're disincentivized to get to the heart of the matter, to fix the problem, to come to a reasonable settlement, because the more you litigate, the more you come before you or file motions or do discovery or take depositions or go to trial, the higher your fee bill gets to be at the end of the day. And you can see how, that doesn't necessarily take care of the client, doesn't necessarily align with the interest of the client, because the homeowner may be fine with whatever the insurance company is proposing in terms of settling the case. But it may be the attorney holding up the whole process because they're not happy with the fee component that had accrued at that point. And so you have this problem of misaligned incentives. And there's countless examples out there of fee awards eclipsing the amount that the insured themselves have recovered by tens of times, 20s of times, 50s of times. And that was out of whack. And so I think that fixing that and removing the one-way fee statute fixes that problem of misalignment in terms of the attorney and the client, because now the attorney's compensation is directly tied to the value of the client's case. And I would note that this is the way it operates in 48 or 49 other states in the country. And it's the way it operates in basically all other facet of the law. If you are in any sort of dispute and you have to hire an attorney, typically it's called the American rule. You have to pay your own attorney. That's the way it works. It's either an hourly rate or they're on retainer and they deduct from that, or what's most common is a contingency fee arrangement where the attorney will take a third typically of whatever the recovery is at the end of the day. But what that does is it ensures that the attorney's interests are aligned with their client's interests, and the more that they can get for their client, the more that they can get for themselves. But before, we had this problem where the attorneys could have been out for themselves and on a much different track than taking care of their clients. So I think that's an enormous change. It's going to take some time, though, for those changes to come into effect. And I think that's something to keep in mind. And something that we're going to hear a lot about is, we were promised, as a citizen, promised all of these changes that were going to reduce rates, but where are our reduced rates? We're still dealing with the lawsuits and the claims that were under this old regime where the costs of litigation are very expensive, and those lawsuits are going to continue for years. And so it's not until we start getting into the new claims and the new lawsuits where we're going to reap the benefit of this better economic environment. And I think we're already seeing it, where there's been some recent news of carriers coming back into the state or having a bigger appetite for business in the state now because the litigation problem is not as big anymore.
Okay. So we only have about a minute left. So I was going to ask about the insurer bill that brought some heightened requirements for compliance. And Vanessa, I was going to ask you, when a policyholder has a complaint about an insurance company, just if you would, in a few sentences, just tell us how that's going and since the bill passed.
That new statute really hasn't come into play.
Okay.
We've got the old statute we're dealing with, the notice of intent. So we have a lot of tools at our disposal still, even though the carrier really has the upper hand in how the claim gets resolved. Really, if they've got a complaint, they have nowhere to go other than an attorney. So this system has been set up to not provide any other avenues other than an attorney to help them. So in other states, I know also there's penalties that maybe you don't get 100% of your fees for the next 3 years, but you're entitled to up to 50% of the damages to assist your attorney in resolving it. So in this case, we're still dealing with litigation, and that's the only avenue we have. There's complaints you can file with the Department of Financial Services, but I've literally never had a claim resolved in 18 years from just filing one of those. They have no power.
Okay. So what about?
So we're forced into a lawsuit basically to even get someone to answer a phone call sometimes.
Okay. And just briefly, how is the insurer, Universal, adapting to this heightened requirement under the new law?
Yeah, sure. So we've had to certainly change our claim handling practices in order to meet these tighter timelines. You mentioned that there's reporting deadlines now, and there are deadlines to acknowledge communications, make claim determinations, and those are all being implemented. We've had to make some changes, but we're going to be in compliance with the new statutes for sure.
All right. Well, I want to thank you both for joining us. I know this is a conversation that could go on for a long time, and we still have a lot to see as it unfolds. And I want to thank you and thank everyone who joined us for this conversation.
For more than 40 years, the Community Foundation of Sarasota County has partnered with estate planning attorneys and their clients to unlock possibilities for everyone who calls our region home. Our motto, Be the One, reflects our deeply held belief that anyone can be a philanthropist and give back to our community regardless of means. Visit www.cfsarasota.org or call 941-955-3000 for more information.